Hi, thank you so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible Kyle Ubel, a Minnesota construction lien law expert. Today's webinar topic is getting paid faster with liens, bonds, and contracts. So without further ado, I'd like to introduce the fabulous Kyle Ubel.
Welcome, everybody. As Jesse mentioned, my name is Kyle Ubel. I'm a lawyer in Minneapolis, Minnesota at the law firm Fredrikson and Byron. And I'm here to talk to you today about how to get paid as a construction contractor, whether you're a general contractor, a subcontractor, a material supplier. The items that we're talking about today will apply to you and your ability to get paid for your work and your supplies. First topic of the day is liens. So liens are a security interest in real estate that's being improved by your work or your materials. And the lien is created by statute as opposed to the common law. And what's important to understand is that when you're dealing with a security interest like a mechanic's lien, that's a statutorily created right, those rights are strictly construed with respect to procedure. And so we're going to speak today for a bit about, at least at a high level, about what the procedure is for securing your lien rights. And it's important to understand that those requirements are what lawyers and judges call strictly construed. It means that you need to comply with the requirements exactly. And if you don't do that, you are very likely to lose your security interest. You'll still perhaps have a claim against the project owner, or if you're a sub, you may have a claim against the contractor, but you won't have a secured claim secured by the value of the real estate that you're working on. It's a big deal. It's also important to note that mechanics liens are not only available to contractors, subcontractors, material suppliers, but also any person performing engineering or land surveying work for a project. And then the last item here is what applies to contractors and general contractors. The lien rights extend to anyone contributing to the improvement of real estate by performing labor or furnishing skills, material, or machinery for the improvement of real estate. In order to have lien rights in Minnesota, you must be properly licensed. So it's very important, if you want to have these security interests securing the value of your work, you need to make sure that you're up on your licensing requirements. And in most states, including Minnesota, that means you need to keep up on your insurance requirements as well. And if those statuses lapse with your organization, you're imperiling your ability to keep your lien or your lien holder status with respect to mechanics liens. Mechanics liens only apply to private projects. They do not apply to public projects. So if you work on a public project in Minnesota, you can't lien public land under the statute. Instead, in that circumstance, you'd be relying on what are called payment bonds. More on that later. So right now, we're talking about work on private real estate. And then the third bullet point is reminding us that there are special rules with respect to homesteads. So in Minnesota, you can file, or rather record, and then sue to foreclose on a mechanics lien on a homestead, but there are certain exemptions and additional requirements that apply to homesteads if you're liening them or foreclosing a lien on them. So you certainly can have a mechanics lien on a residential project that relates to someone's homestead, but there will be additional requirements and some procedural hoops to jump through to maintain those liens and enforce them. Now let's talk, at least at a high level, about what the process is for preserving and maintaining a mechanics lien in Minnesota. The first step is that the contractor, if you are the contractor, you need to give pre-lien notice in the written contract, or if there is not a written contract on the project, you need to provide separate notice within 10 days after the work is agreed upon. So if you have a handshake deal, within 10 days of the handshake, you have to give separate written notice that you intend to assert lien rights with respect to the property. Always best to have a written contract, always best to work with your lawyer to make sure that the appropriate language for pre-lien notice is right into your form contract so that you don't need to ever worry about it or think about it. It's just automatically there as part of your form agreement. The second piece is with respect to subcontractors. Subcontractors also need to give pre-lien notice And they do that via personal delivery or certified mail delivery of the appropriate subcontractor notice within 45 days of your first work on the project. Again, those forms are readily available, but probably good to work with your lawyer if you haven't already, to make sure that you're using an appropriate form for that if you're a subcontractor. Again, these are statutorily prescribed notices. They're set forth in the statute, and there's particular requirements in the statute about the language that needs to be used, the font, the sizing of it. It's literally that technical. And so those formal requirements are strictly construed. And if you send out no notice at all, or you try to send out a notice, but it's not formatted correctly, that could end up being an issue later on with respect to your ability to have a lien. It is that technical. Then we fast forward to, you've done the work, you've put in your pre-lien notice, you've done the work, ready to get paid, your work's done. Then you need to do what's called the mechanic's lien statement. This is the same for both contractors and subcontractors and material suppliers. This one's not different based on what your status is on the project. Anyone who's performed work or provided materials for the project that wants to maintain a lien has to, within 120 days after their last contribution to the work, file with the county recorder a written mechanic's lien statement. And that's also, it's not only served with the, strike that, it's not only filed with the county recorder, you also serve it on the project owner, again, either by personal delivery or certified mail. Both of those things have to happen. You have to record it with the county recorder, and you have to serve it on the owner in one of those two delivery methods. Again, these procedural requirements, like the earlier ones we've been talking about, are strictly construed, or your lien rights are lost and they cannot be recovered. So you have to make sure that you're complying with these rules. It's important in the mechanic's lien statement, this is one trap for the unwary, that you cannot overstate your amount. So if you've done $100,000 of work, it's very important that in your lien statement, when you say the amount of your lien, that you only put down $100,000. You can't be off by a little bit and overstate the amount. So if later on you put in a $100,000 mechanic's lien statement, but later on in a foreclosure litigation, for example, an enforcement case, the project owner shows that your mechanic's lien was only properly for $90,000, excuse me, you will lose your lien. Not just for the $10,000 difference, you'll lose your entire lien. So it's very important that you're confident about your accounting, you're confident about the value of the work you've done, and that you do not overstate the amount in your mechanic's lien statement, because if you do, you could potentially jeopardize the entire lien. The other thing I'll note with respect to last contribution, when you're timing when your 120-day clock starts, it has to be your actual last material, legitimate contribution of work. What ended up happening is contractors and subcontractors would realize that they were a little bit past that 120-day period. So they'd go back and they'd tinker with the screen door that was a little squeaky, or they'd work on that hinge a little bit with a can of oil, right? And then they'd say, oh, well, now we got a new 120 days because we came back and we did screen door work. And the reason I use that example is because there's actually a doctrine, a court-created, court-ruling doctrine called the screen door doctrine, which says contractors and subcontractors and material suppliers cannot resurrect an otherwise dead lien by going back and doing so-called screen door work. It's called the screen door doctrine. So you can't go back and just do little tinkering and little tweaks and then say, now I have a fresh 120 days. You got to actually pay attention to when you've done your last substantial material piece of work. And when everyone understands that you're done based on that last substantial contribution, that's when your 120 days start, and you're not going to be able to resurrect it with screen door work. You also will not be able to resurrect it in most circumstances with warranty work. So you got to really pay attention to when you're done. You know, make a calendar entry with your office on when the 120 days runs, and make sure that you have your stuff done with your legal team or your outside counsel in terms of recording the documents with the county recorder. So you do your work, you've sent your final bills, you've recorded your mechanic's lien statement, you hope you get paid, and then you don't. So then what's next? Couple things. In Minnesota, you can foreclose a mechanic's lien either by action through a traditional lawsuit, or you can do it through a non-judicial, a non-lawsuit proceeding called foreclosure by advertisement. And there's different reasons why you might choose one over the other, and that's not really the topic of conversation today. That's probably a webinar all onto its own, the differences between foreclosure by action and foreclosure by advertisement. But suffice it to say that the next step in the process would be foreclosing on the lien through one of those two methods. Typically at this point, you'd be employing a lawyer to help you with that. And you'd be working through with the lawyer what the priority of your lien is in trying to develop a strategy about whether it even makes sense to foreclose the lien. Because you can imagine if the project owner has $1 million mortgage that was recorded before you ever started work, that mortgage for $1 million is superior in priority, has a higher priority in the lien flow on the real estate record. It has a higher priority than you do. And if they're underwater on that loan and the project's worth $800,000 and they're already underwater with respect to that first loan, may not make sense for you to even go through the time, money, and effort of foreclosing your lien because the project's already underwater with higher priority mortgages or encumbrances. So that next step would involve a priority analysis that you do with your lawyer, who would typically work with a title company to help you figure out what else is out there ahead of you. So that's liens for private property projects, private real estate. As I mentioned earlier, you cannot lien a public project. So on public projects, payment bonds are used. And in particular, public projects in excess of $75,000 in Minnesota require both a performance bond to be used and a payment bond. Very briefly on each of those. So a performance bond is not actually about you getting paid. It's about making sure that you perform. And if you don't perform, and it's going to cost the municipality or the public project more money to have someone else come in and do it, they're bonded against that risk because public projects are not set up to absorb non-performance risk. So they build into the budget the cost of procuring a performance bond to basically insure against the risk of non-performance by the contractors and subcontractors. The flip side of that coin is they're also required to budget into the process the cost of procuring a payment bond to make sure that you all get paid. And so in the event that you don't get paid, as opposed to seeking lien rights, you'd make a claim against the bond company, which is basically like an insurance policy, and you'd work through that process with your lawyer to get paid through the payment bond issuer. So we've talked now about liens and bonds, which are essentially security interests. But what they're securing is your contract rights. So like a bank has a note with a homeowner, and the note, the promissory note, is the contract that says that the homeowner has to repay the bank. The mortgage is the security interest securing the promissory note. In your circumstance, your contract is whatever written agreement. Again, we said at the beginning, you should always have written agreements. Don't do handshake deals. They're not good for you. Your contract with the project owner, if you're the general contractor, or if you're a sub, your contractor with a general contractor, that's like your promissory note. And the lien or the payment bond, depending if it's private or public or private project, that's like your mortgage. So it's equally important to understand what your contract rights are, because if you don't have a contract right, it's difficult to enforce your security interest in something. So you want to make sure you have a good written contract so that if you don't get paid, it's easy to go in and assert a claim for breach of contract, get a money judgment, and then it's that money judgment that you're going to use to establish your mechanics lien case, legitimize your mechanics lien case, and then foreclose. It's also important because in the event that for some reason you have an unsecured claim, you lost your lien right, or you didn't get a payment bond, you can still collect your money damages on breach of contract through your standard money debt collection efforts in Minnesota. For example, you can still get a judgment lien on real estate. You can seize money out of bank accounts. You can seize assets in certain circumstances owned by the business or the person owing you the money. So it's very important in Minnesota to have a sound, well-drafted, appropriate written contract so that when things go south, and they will at some point in time, something will go south, you've got a good written contract that your lawyers reviewed that will allow you to have a good high likelihood of success breach of contract lien. Finally, in the event you don't have a written contract, and again, I hesitate to even tell people about this because I encourage everybody to have a written contract, but you also can sue for unjust enrichment or what lawyers call promissory estoppel or quantum meruit claims. And all of those are fancy phrases for we had a handshake deal or we didn't. I just showed up and put a new deck on your house and your house was improved and you've maintained the benefit of that deck. Even though I don't have a written agreement with you, that deck improved your real estate by $25,000. You still owe me the $25,000 even in the absence of an agreement. The reason I do mention this is I want everyone to understand that even if you don't have lien rights, even if you don't have bond rights, even if you don't have a written contract, if you've done work for someone and they've not paid you and your work improved the value of their property, you still have the ability to assert a claim against them. And in certain circumstances, you can win that claim and still collect against them. So please be aware that even if you feel like you're in a tough spot, things didn't go quite right procedurally, you didn't do all of the homework ahead of time, that doesn't mean that someone doesn't owe you money. You should still reach out to a lawyer and we can still help you. With that, I think we usually set aside 20 or 25 minutes for these things. So I like to leave a little time at the end for questions. So Jesse, did we have any questions come in today?
Well, first of all, thank you so much, Kyle. You really were incredible. And yes, I can't second your sentiment that, you know, written agreements are best, or written contracts are best. Please, please, please make sure that you guys are getting yourself set up for success and that you have everything laid out and what is expected of you and what is expected of your customers. As far as the questions, we do have a couple that have come in. This one I believe you touched on already, but are there any differences in the deadline to file a lien between residential and private commercial jobs?
No, those requirements are uniform across all kinds of projects. So again, just to reiterate, it's 120 days from last work. You have to record the lien statement, and you have to, if you're not paid, you have to start the foreclosure process within a year of your last work. So it's 120 days to record the statement and serve it on the owner, and it's a year from last work to foreclose on the lien if you're not paid.
Perfect. And remember, please do not wait until your very last deadline date to get something filed. It does take time. Make sure you're reaching out prior to that deadline to get yourself set up for success. And then another question that came through, and this is kind of tagging on to what you've already spoken about. Are there any priorities given depending on who files the lien ahead of you, not just on the mortgage?
Good question. So it does flow in order of priority based on when work is started. So unfortunately, that does mean, you know, if you're somebody that comes in at the end and you your first contribution of work is 6 months after someone else's, it does come in based on first contribution to work, and that actually gets played out quite commonly in foreclosure cases. If it's the, you know, you'll recall we talked about the difference between judicial foreclosure and foreclosure by advertisement, and you'll often see that when the general contractor, for example, was foreclosing the lien, you're not required to name as a defendant in the lawsuit folks with higher priority, but you are required to name everybody with junior priority. And so you'll see, for example, when the general contractor sues out a foreclosure on their mechanics lien interest, they'll name as defendants all of the subcontractors because all of the subcontractors have a subordinate priority to the general.
All right, perfect. Thank you so much for that clarification. Seems to be all the questions that were asked. If anyone does think of another question that wasn't addressed, please feel free to reach out and I'll be sure to answer those questions for you. Here are some, can you go back to the last slide for me?
Of course.
Thank you. Here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access all of the resources available. All right, now you can go on. All right, so our next webinar with Kyle is going to be May 14th at 2 p.m. That's what happens after I record my lien. How do I get paid? So please go ahead and register at sunraynotice.com/education for free. We'd love to be able to see you guys there. All right, and then the next one All right, if you don't mind, give us a moment of your time, give us some feedback and a review on Google. We really do love to hear what you guys have to say and how we can better ourselves in our webinars to meet your needs. And then the last slide, if you don't mind. And with that, that is all we have for you guys today. Thank you so much for everyone who attended. We hope to see you at our next webinar. Again, Kyle, you really are incredible. I hope you all have a beautiful and wonderful sunny day. Thanks, everyone.